Sometimes it is not possible for parents to resolve disagreements by themselves. When this happens, it may be necessary to involve a third party to help come to a resolution. Of course, you can go to court to resolve disputes, but let's look at the differences between making an agreement and going to court. Making an agreement between yourselves is not very expensive. It usually takes less time. It is a cooperative process. You decide your own agreement. The emphasis is on win-win. An agreement you reach yourselves helps to narrow personal differences. Going to court may be expensive, usually takes more time, is competitive, the judge decides there is a win-lose emphasis, and it widens personal differences.
Before we explore options for resolving disputes that involve third parties, let's talk about situations in which you and your partner agree. If you and your partner can talk openly and agree about plans for the child, and there is no safety issue involved, you can develop a parenting plan together. Consider putting your agreement in writing after getting legal advice. Remember, if you feel threatened by the other parent, do not negotiate on your own. Consult a family justice counselor, an Aboriginal court worker, your band social worker, your family support worker, a counselor, or an elder.
Here are some guidelines for negotiation. Before you get together, gather all your information and facts.
Choose a neutral place and a time when you can talk without interruption.
Decide together on rules for how you will talk respectfully to each other. For example, you may both agree you are going to stop the meeting if either of you starts raising your voice, interrupting, or blaming the other for the separation.
Speak clearly about what child-related issues you want to discuss. Stay focused on the topic. Don't bring up past faults and problems.
Ask the other person for their point of view. Listen carefully to what the other person has to say. If you don't understand, ask for more information.
Look at solutions together and give your solutions as suggestions rather than demands.
Make sure both of you agree on the solution. Specify who will do what, when, and where. For example, if the agreement is about when the other parent will spend time with the children, you should have a written plan about how and where the transfer will take place and what time the children will go and return.
Plan to meet again to review how the agreement is working.
At the end of the meeting, give positive comments such as, "I feel better about this, and I'm glad we were able to work it out together."
Legally, it's not necessary to have a separation agreement or a court order, but by writing it down, everything is clear and there is less chance for confusion or problems later. A written agreement is a contract between you and your partner that says what you have both agreed to.
A written agreement can also include all your decisions about custody and access and about child support. It can also include your decisions about how you are going to divide the things you own and whether one parent is going to contribute to the financial support of the other. Remember that when you are discussing child support, you should follow the child support guidelines. All decisions relating to children must be in the child's best interest.
Make sure both you and your partner sign the agreement. It's also a good idea to see a lawyer before you sign an agreement to make sure that you have protected your rights. Your partner and you should see different lawyers, so don't go to the same lawyer.
If it is a feasible option for you, you may wish to file the agreement with the court. If there are problems later, you can show a judge what you and your partner agreed to. Judges take these agreements very seriously, especially if you both had legal advice. You can also make your agreement into a consent order, which is a formal order a judge makes in court to affirm the agreement before signing the agreement.